went to William and Mary as a philosophy and government major. Basically, government is political science at William and Mary, but spent probably most of my time at the college radio station. I did the logs. I was the general manager one year. I did a lot of radio shows, and it was a time when our college radio station was very active at William and Mary. We had a number of folks go into professional radio, a number of folks who actually became owners of stations. My first clients were some of the folks I worked with at the William and Mary College radio station. In fact, a group of us looked at building or buying our own radio station while we're at William and Mary. We hired some communications attorneys in DC to help us and some consulting engineers to look for open frequencies. So I got lots of experience in a group of the folks that I was with. Did file for an open frequency down in North Carolina, eventually got it. They had a bit of a falling out. I represented half of them. The firm that we hired while I was in undergrad represented the other half, and we worked out a deal. So one of my college roommates ended up owning the station as one of many that he owned.
Well, we have somewhat of a similar background because I came out of political science at Illinois and worked with Roger Rafson, who connected us here.
Sure.
He was our station general manager the year I was news director. And I think I did everything but GM at the radio station down in Urbana. But likewise, there was a group before our group that had tried to get an open frequency in Kalamazoo, Michigan.
Oh yeah,
and had gotten
exactly.
That's right, and had gotten pretty far into it, and didn't quite make it to the finish line.
No, they got their station.
Did they finally get it?
Yeah, they did get their station. I know Ed quite well. In fact, the first firm I worked with after law school represented it was the Airborne Group in running that station up in Kalamazoo. They eventually sold it, and Ed worked in government for a while. With one of the congressmen from Michigan, from that area in Michigan, and now is retired and enjoying life.
That's interesting because I think I lost track of it somewhere in the process. I graduated, and then I knew they weren't owning it later, and so it's interesting that they did get it. That was a pretty lengthy process, wasn't it, to try to get a radio station frequency if you didn't have any history of broadcast ownership?
Yeah, it was. I mean, back in the day when that was happening in the 70s and 80s, in fact, through to the early 90s, in order to get a new broadcast frequency, the FCC would generally hold a comparative hearing. And a comparative hearing would assess the qualifications of the people who were applying for the new station, if there were more than one group applying for a particular open frequency. To determine who would best serve the public interest. And it was an analysis that looked at a couple of different factors. One of the factors was how many of the owners, what percentage of the voting owners would actually work at the station on a day-to-day basis, to try to make sure that the ownership was responsive to local needs because the people were actually working there. And the other was to increase diversification of the ownership of the broadcast media. So you got essentially demerits if you had other broadcast ownership interests. And those factors were used. And, it seems like pretty objective factors that you could figure out on paper, but you could construct applications in such a way that you maximized your credit and tried to minimize some of the demerits. And you also got additional plus credits if you were essentially tied on the percentage of ownership that was working at the station for people who had past broadcast experience, people who were members of minority groups or women who the FCC wanted to encourage to get into ownership, people who were local residents because they wanted local folks to be owners of the stations. So it got to be a very complex analysis that could take 7 or 8 years, in some cases even more, to litigate all the way through the FCC and then into the courts.
So by
And that's all gone away now. It's all done by an auction now.
right. And so by definition, back then you had to have enough resources to stay in the game, right?
Correct. Either that or very patient attorneys to help you through the whole thing.
So, and I also see Roger Rafson has joined us, who connected us. Roger was our WPGU general manager. How did you get from there, Roger? I lost track, into the business that you got into.
Well, first, I apologize for being late tonight. Well, I was, I had my own radio station rep firm, bringing advertising revenue to stations for many years. And over time, I realized that many of the people I were dealing with were station owners, some of whom were getting older and wanted to retire and sell off their assets. And other people I was dealing with were people who had groups and they wanted to expand their footprint and buy more stations. So I realized that I knew these people and that I could be a media broker. So I started that business as well. That's called CMS, Station Brokerage. And that's how I came to know David Oxenford.
And so these properties, once you had a broadcast license, David, became very valuable at times, didn't they? In terms of if you chose to at some point sell the station, it was worth more and more over the years in the 70s and 80s and 90s.
Sure, early 2000s. I mean, radio stations were very, and Roger could probably talk about some of the valuations, but you were seeing FM stations in major markets selling for, in New York, the station sold for $200,000, an FM station. I mean, $200 million. I'm sorry. And that's not the case anymore. But through the early part of this century, prices really rocketed up for broadcast stations because it is a limited spectrum. And up until the advent of digital audio on the internet, there really wasn't competition. So there were a limited number of opportunities to reach the public on these frequencies.
So there were two parts to a sale, right? Actually brokering, Roger, a station from one owner to another, and then being reviewed by the Federal Communications Commission, David, and determining whether the new owner served the public interest, convenience, and necessity?
Well, that, if you're asking me, yes, that's true. The big part of it is to put the buyer and the seller together, for them to talk and have a meeting of the minds. And then the broadcast attorney takes over and gets the application filed and gets it through the FCC for approval.
Right. It prepares a contract to do the sale, just like a contract for anything else that you're going to buy, any other business that you're going to buy, with representations and warranties to make sure that you're getting what you think you're getting. Then you file that with the FCC. The FCC takes public comments for 30 days. It's still the process today, where the public can object to the new buyer. And then the FCC considers any objections that are filed and acts on the application. Basically, the objections now are not that somebody's going to be better qualified if you sold the station to somebody else, but instead it's just a question of the basic qualifications of the proposed buyer to buy the station. Basically, are they U.S. citizens? Or do they have any character problems in their background, where they're criminals, or where they've been convicted of lying to another government agency, or where they've had media-related antitrust issues, or where they've had discrimination problems, or some other character type issue that would go to their ability to operate a radio station or a TV station in the public interest. The FCC will look at those sorts of objections to an applicant. Probably 98% of all applications go through without any objections. So it's a 2.5 month process from filing to the FCC's grant, But where there are objections, it can take a long time for the FCC to evaluate those objections, depending on how serious they are and what issues they raise about the potential buyer. The other thing that the FCC looks at is there still are ownership limits on the number of stations that you can own in a particular market. In radio, in the biggest markets, you can only own 8 stations, 5 of which are FM, 5 of which can either be AM or FM, and the others have to be in the other service. In the biggest TV markets, you can own 2 TV stations and no more. So the FCC looks at those issues as well.
And they've lessened those restrictions, those ownership restrictions over time a little bit, right?
A little bit, but essentially the radio restrictions have been in place since 1996, those same restrictions. The TV duopoly rule was, I guess, loosened to own 2 TV stations in the early 2000s. And in fact, at one point, it was in the largest markets, the FCC said you could own 3, but that was rolled back. So right now it's 2. And the FCC every 4 years does what's called a quadrennial review of the ownership rules. They're in the middle of one right now. They did another one in 2017. In 2017, they got rid of rules that had prohibited owners of daily newspapers from owning broadcast stations in the same market. That rule had been adopted in the 70s when newspapers were the dominant sellers of local advertising in markets, and really the dominant source, I think, of local news in many markets. It didn't make so much sense anymore when the newspapers are barely scraping by in most markets. And really the FCC has been trying to get rid of that rule for almost 20 years and finally did get rid of it in 2017. They also loosened up a couple of rules that said you couldn't combine 2 TV stations in the same market unless there were 8 independent voices, 8 independent TV operators in that TV market. They got rid of that rule. Now it's just a limit that, except unless you can make a public interest showing, you can't combine 2 of the top 4 TV stations in any market. On the radio side, that's one of the things that's before the FCC now. Should they loosen the local ownership rules and allow one owner to own more than 8 stations in New York or Los Angeles, where there are, I think in New York, or in Los Angeles, there are over 100 radio stations that serve parts of those markets. Should you be allowed to own more than 8? Especially since more and more you've got the Spotify's and Pandora's and Apple Music and Amazon Music and Sirius XM and YouTube really serving many of the same audiences as the radio stations, especially in the music area, and a million podcasts serving the same audiences as the news talk stations. And do these rules make any sense anymore, limiting the one owner to owning 8 over-the-air radio stations in those markets? You know, as I said earlier, the value of stations has plummeted. In fact, I recently did a deal for one of my clients to buy big FM stations in New York, Atlanta, Washington, D.C., and 2 smaller markets where they paid $120 million for stations in all 5 markets, when again, 10 or 15 years ago, one station in New York would have been $200 million. So I mean, the prices have really changed significantly.
But I think it's difficult when I first start to work with students early in the semester, and they read the broadcast regulation chapter in our book, to understand in this streaming audio and video era that we now live in, the concept of spectrum scarcity as a rationale originally to kind of order the spectrum, avoid interference, and limit the number of stations that could be licensed by the FCC.
Yeah, it is kind of strange in today's world when you can start an internet radio station on a service like Live 365 or one of those other services and start streaming to the world yourself with essentially no regulation other than imposed by the copyright rules. And broadcasters still have all sorts of regulations about public service obligations, about public files that they have to maintain to alert the public about how they're serving the public interest, limitations on certain kinds of advertising that can be done, certainly limitations on indecency and material that they broadcast over the air. Limitations on political advertising, for instance, are huge issues. I spent most of 2020 looking at political ads that were going to be running on radio or television stations to make sure that they complied with FCC obligations, because the FCC has very specific obligations on, particularly on sponsorship identification on rules, and also on the pricing of political advertising rules, none of which apply in the digital world. So the competitors in many ways to the broadcast stations are totally unregulated or virtually unregulated in these areas, while broadcasters have to adhere to a whole, got my rule book here, here we go, visual aid, the rule book just on the broadcast sections right here. It's a lot
put in place in 1996 before the internet really took off.
Right. The ownership rules that are in place now were adopted in 1996. In 1996, none of these streaming services, I guess actually Live 365, I think, was born in 1996. But Pandora was, I think, 2006. YouTube was 2005 or 2006. Spotify didn't launch in the US until 2011 or 2012. And, Apple Music and Amazon Music are both relatively new players just in the last 5 years to the music scene. Yet both are gathering large audiences. And also, it's not just a competition for audiences, but it's competition for advertising dollars. In every rated radio market now, digital advertising comprises more than 50% of the local advertising dollars. The dollars at the local restaurant, the local hardware store, or the local car dealer. All of that used to go to radio and newspapers and TV. And now over 50% of that goes to Facebook, Google, now Amazon, and I'm forgetting one other of the big digital media. Oh, Google. Well, I said Google, Facebook, Amazon, and there's one other big one that I'm sure. I'm sure I'm forgetting. It's not Twitter. Twitter does do some advertising, but over 50% goes to these out of market digital advertising services, because everybody's got their website that they want to promote. Everybody's doing Google AdWords. Everybody's trying to drop in ads into Pandora or the ad supported side of Spotify, and that is money that used to support your local media. In fact, now what we're seeing is that Congress is looking for ways to help support local media, because they recognize the drain on the local media sources. There are a couple of bills pending in the current Congress that would help support local media, not just broadcasting, but also local newspapers. One that would give a tax credit to subscribers to local newspapers, and a tax credit to local media outlets who hire journalists of, I think it's up to $15,000 per year for each local journalist that the media outlet hires. There are discussions and a proposed legislation that would allow the broadcast industry or the newspaper industry or other traditional media to get together collectively and negotiate with digital media sources for the use of their content on those sources. It's what some of you may have read about that happened in Australia. Australia not only mandated that these existing media, traditional media, could get together and negotiate collectively with the Googles for putting links on in their search engines, or using clips on YouTube or whatever, but also mandated that if they couldn't reach an agreement, there would be a government agency that would set the rate that would be paid by these digital companies for the use of this content. In the US so far, the legislation doesn't go that far, but it does allow for collective bargaining, so that the entire radio industry, or the entire TV industry, or the entire newspaper industry, or some subset of the industry could get together, collectively negotiate that would otherwise be prohibited by the antitrust rules, to try to reach a better deal with these tech giants that are hundreds of times bigger now in terms of the size of their companies and the market value of their companies than the collective radio industry altogether. Every radio station in the country is probably 1/100th of the valuation of a Google or a Facebook at this point. And the TV industry is only slightly larger than the radio industry, maybe 2 or 3 times. So they dwarf, the tech industry dwarfs those broadcast industries.
It's a fascinating point to me because, I came up in an era in which the FCC was promoting localism, both, with new licensees and renewals, if there were complaints and there was a review process, how much you could be local and assess community problems and needs was a factor. And we seem to have come so far from that. And it seems to me the impact on many of these students is that the number of jobs here in Omaha and elsewhere in other markets, it may not be as large. I know newsroom sizes became much smaller in this era of shrinking advertising revenue.
That's correct. I mean, most radio stations have maybe a news person for an entire cluster, not a news bureau, so to speak. TV is better in terms of local journalism because there still are. Local news is one of the big sources of revenue for TV, especially as more and more people find their entertainment through the Netflixes and Amazon Prime and Disney Plus and HBO Max and every other streaming service that there is now. News is one thing that TV stations can still sell in their markets because they are local and the big providers of that. So they do still hire local journalists. It's also interesting in the way that Congress and the government is talking about the tech industry now. There is a lot of effort being devoted on Capitol Hill and now in the regulatory agencies, particularly the Federal Trade Commission, with some of the appointments from the Biden administration. The FCC has not yet been firmed up as to who will lead that, but the FTC in particular is looking at big tech and whether the government should be looking at breaking up some of the industries. The FTC has filed suit against Facebook to undo some of their acquisitions of Instagram and WhatsApp. Congress is looking at ways to regulate the big tech. 10 years ago, it was just the opposite. 10 years ago, the FCC was looking at ways to encourage big tech or encourage tech at that point. It wasn't big tech yet because, a lot of the thinkers at that time thought, people would have the ability to bypass all the gatekeepers. They wouldn't have to have their messages filtered through the owners of newspapers and broadcast stations. They could directly reach other citizens and get their views out there. And now the government's almost saying, oh my God, people can bypass all the gatekeepers and get their messages out directly to other people. And there's no limits on what realizing there's now no limits on what they can say. Nobody who's editing some of the content that gets out there, leading to a lot of the questions about misinformation that we're, dealing with every day. And so Congress is looking at ways to rein that in.
Our study groups last week were looking at terms of service agreements and user agreements for Twitter and others. And of course, Twitter has been very active in trying to, ban accounts that violate their rules, whether it's hate speech, harassment. It seems as though, and some of our students have been talking about this, it seems as though the power has really shifted to these social media platforms in terms of the editing and the gatekeeping.
It has. And in fact, some in Congress want to put more obligations on these companies to do more to make sure that they're editing. I mean, not just putting stuff in context, which is a lot of what Twitter does, I think. They do take some stuff down, but they put a lot in context by raising questions about whether it's accurate. And I guess Facebook does a lot of that too. But there are some in Congress who want them to have more liability and more responsibility to edit misinformation. But there are others on other parts of the political spectrum that want some of these platforms to not take such an active role. There was some legislation passed in one house of the Texas legislature that would essentially ban these platforms from censoring one side of an issue, if you will. If they put posts up on the other side of an issue, defining that very broadly, that would seemingly encourage or give legal obligations to these sources to carry what many consider misinformation. That same kind of legislation was already passed in Florida for political candidates. If you put one side on, you can't ban the other side, even if they're saying stuff that's outrageous, basically stemming from taking down President Trump's accounts after some of the post-election stuff that he was posting on there.
I mean, that too, to me, seems historically strange in the sense that when Section 230 was passed, it was almost as if we were saying these internet service providers were common carriers. They weren't in the business of making editorial decisions. And likewise, the complaint that broadcasters had when I started in the industry was that they were second-class citizens because of the Red Lion decision compared to Tornillo and the right of reply statute that was struck down in Florida. So it seems like we're revisiting all of these issues now, isn't it?
We're revisiting everything. In fact, a lot of these state statutes that are purporting to regulate the online services, I'm not sure how they're ever going to survive a constitutional review. The argument is, oh, they're the same as the town squares. So the public should be able to speak freely on the town square, but the town square is public property. And there was one Supreme Court case that once said a company town that was owned by a company, even though it was private property, functioned the same way as a town square, and therefore should be accessible to people protesting, particularly against that company. It was a mining town, I believe. But then there were several cases after that said shopping malls are not the same as town squares, even though, in many instances they function that way. That's where everybody came to shop and gather and hang out and go to the movies and everything else, stuff that they used to do in traditional public spaces in town squares. And the Supreme Court in a couple of cases held that shopping malls were not the same as town squares. And it would seem to me that would apply just like that to these digital platforms, because they're privately owned. They're private speakers. They ought to be able to determine what content that they put up and what content that they don't want to put up. So I think it's going to be difficult for that to survive First Amendment scrutiny, but we'll see.
Do you think that we are entering an era also where this distinction between government action, state action, and non-governmental action is a little bit fuzzier because of platforms like Twitter? If we're going to impose these responsibilities on private companies, aren't they in a sense acting as an arm of government? If, for example, police want materials, want to be able to search their archives for potential crimes, that kind of thing?
I mean, the government is subject to all sorts of obligations under the Constitution that private citizens aren't. All the due process rights and all the First Amendment applies to government actors, not to private actors. There's no First Amendment right to compel your speech on any private platform or to regulate the speech on any private platform. And it protects private platforms' ability to speak and make decisions about what's carried on those platforms. So to extend those obligations of the government to these platforms, to treat them as government actors, I don't see that. Don't see that happening. Consistent with traditional constitutional holdings, but again, things change. But I just wouldn't see that happening, and I'm not sure it should happen. To start putting obligations on private actors to function as the government, the more that you do that, the more, I think there are real concerns with outsourcing the government decisions to private actors. I mean, look how much trouble Facebook has had in trying to set up their board that's supposed to censor or make determinations as to what meets their community standards and what doesn't. I mean, everybody has a dispute about every decision that they make, and the decisions take forever. I mean, they're as bad as the government. To impose those obligations on these platforms to act in a governmental way, I think raises all sorts of constitutional issues. And then to judge that by the government to determine whether they've done a good job in policing it gets the government into all sorts of questions about judging what is right and what is wrong in speech areas that, I'm not sure you want the government drawing those lines either. So it's a thorny area, and it's an area that's got lots of complications.
Well, one of the complications that we haven't gotten to yet is this global internet. So if we get beyond what the Congress does there in Washington, D.C., or what the California legislature does in Sacramento, or the Florida legislature does in Tallahassee, or Illinois in Springfield, or here in Lincoln, Nebraska, the unicameral. Beyond that, there is this kind of global push through GDPR and privacy regulations that seems to be impacting where Facebook and these platforms may be going. Is that fair to say?
I mean, privacy is a whole nother subject too, and a major subject of regulatory pushes all over the place. Europe is further along in imposing privacy regulations than most of the United States, except sort of California has their own privacy regulation, but the rest of the US has very limited privacy regulations, essentially, that you tell the truth about what you're going to do with private information and not try to mislead people with what you're doing in some regulation on privacy for kids, but not general privacy regulation like there is in Europe on most companies in the United States.
It somewhat surprises me that, in light of the fact that we have HIPAA for health records and we have FERPA for the students' educational records, Congress went that far, that there hasn't been more serious at the federal level attention to the privacy issues. There's no consensus, is there, in DC?
There's no consensus. There's lots of attention. I mean, throughout the last couple of Congresses, there have been all sorts of battles about what the privacy legislation should look like. The FTC has also been very active in looking at it. In fact, they just appointed a new commissioner. The Biden administration just nominated a new commissioner to the FTC yesterday, who's been a real advocate for additional privacy regulation. So, there may be more action in that area, but it's difficult to write rules that everybody is willing to live with. So much of our internet culture and our internet commerce is based on using information gathered from users, and many of us give it away every time we sign on to a particular website and check that box. Oh, sure, use my information for whatever purposes. It's hard to put that genie back into the box, if you will, because so much is already out of the box and so much of our information is already out there, and so much of the internet is dependent on that information. Google makes lots and lots of money by being able to target ads based on where you've been before, and as do many other ad services.
Well, our time is getting short, so I want to open it up to any student questions. I know we had some in Canvas earlier, and I think we've covered those in general, but do any of you have, who are here with us representing the study groups, questions from your groups?
I have one for whoever you guys want to cover it. I know you touched on a little bit broader, but today's day and age, you see podcasting, especially social media, all the stuff online that goes into it. How much has that changed your work to kind of have to manage all those other regulations that go into it?
It certainly has changed my work. I mean, I do actually a lot of work with webcasting companies on digital music royalty issues, and with podcasting companies about content issues and other matters for podcasting. Just general contractual issues and setting up relationships and podcasting networks and things like that. That didn't really exist when I started practicing in the 80s. It wasn't until 2000 that we started getting into those sorts of issues. And now that takes up a fairly significant block of my time. But there's still plenty of broadcast regulation. And still plenty of lawyers that don't get into these digital media issues at all. So yeah, personally, it's changed my practice, but other folks have stayed very busy just on the traditional FCC regulatory side for broadcast companies.
Roger, many of the students in this class are seniors or close to seniors thinking about graduation and a career ahead. Do you have advice for them compared to when we were in that situation to today? What would you tell them?
Well, broadcasting is a wonderful career. I'm delighted to still be in it. When I was a senior, I remember all of my friends who were engineers and accountants. The big firms would come to campus and recruit them, but that wasn't the case for people who wanted to go into broadcasting. I had to set up appointments and go to their cities and have those meetings. And that's what I did. Now we have Zooms, it makes it easier. But yeah, stations are telling me every day that they need more people at their stations, specifically the big thing that they need are people who will help them produce revenue, sellers. There's always opportunities for sellers in broadcasting, radio and TV. But people also like to create content. And so people who want to be disc jockeys or newscasters, news directors, sportscasters, there's always opportunities for that as well.
Engineers too. There's
yeah.
a real lack of people going into the broadcast engineering world because so many people are going into the tech side of things, the digital side of things. So a lot of the broadcast engineers are aging out. There are some states where there's one broadcast engineer basically working with all the stations in the state. So there are real opportunities there. There's also a lot of opportunities for younger folks to get into the broadcast industry, to help the broadcast industry with digital content production, because more and more broadcasters are doing more and more in the digital world, both exploiting social media pages and social media sites to repurpose their content and expand their reach, and also to do things like podcasts and YouTube channels, even for radio stations, to expand the ways that they interact with their communities. And unfortunately, a lot of the folks who have been in the broadcast industry a long time just haven't grown up with that and aren't as familiar as a lot of you no doubt are. So there are plenty of opportunities in the digital side of things in the broadcast world as well.
When you mentioned the FTC earlier, I also thought of the growth in social media influence as a career, but also we'll be reading about it here and talking about it shortly, the regulations that impact them in terms of transparency and disclosure of income. Is that something that talent is getting educated on through lawyers and others to be careful of that minefield?
I certainly include it every time I do a webinar on digital media issues. Yeah, I mean, it's always been for broadcasters part of the requirements of the FCC. It's the whole payola issue. If you're paid to say something on the air, make sure that it's clear that you're paid to say something or play something on the air. The sponsorship identification requirements, and the FTC has now extended essentially those same requirements to the digital media world. And those rules have been in effect for essentially 15 years. That if you're paid to convey a message, or if you get anything of value, in fact, the rules are even broader. If you get anything of value to make a digital media post or comment, you've got to disclose that you got something of value. Even a reviewer of electronic devices, if electronic companies are sending them free devices to review, or somebody who's reviewing records or movies, if they're getting free CDs or screeners of the movies, they've got to reveal that they got that or tickets to the movie theaters in their posts. That's why you see so many Twitter influencers with a hashtag, or Instagram hashtag ad, because you can't, in some short form media, you can't put a whole lot of information, but you at least have to identify that it's sponsored. That's why there'll be a hashtag ad on so many of the influencers' Twitter feeds, for instance.
I just have one final question, and then we'll let you get out of here and get to dinner. It seems to me that we are entering or are still in an era where the future is going to be very fascinating. Do you have one or two watch areas, and this is for both Roger and David, one or two areas that you think looking forward in the next 5 to 10 years are absolutely areas that the students should be focused on? And I ask because they're going to be writing research papers where they try to look to the future. What are you keeping an eye on for the future beyond what we've already talked about?
Roger, you want to go first?
Well, streaming is going to be huge because bandwidth will increase, or maybe it'll become better digital, or however it'll go through the tubes to your projector or your computer. People can just have a studio in their home or in a small office, and they can broadcast to the world. I think that's the promise of the internet that has yet to be realized. I think that more and more people can have voices that really get out there.
I think there are a couple of different places that students ought to be watching. One is copyright regulation. I've talked a lot about radio because I do a lot of radio work. The digital music rights are really expensive once you start to grow to be a significant streaming company. Even for small webcasters, that's one of the biggest hurdles to starting your own internet radio station, is paying the music royalties, because every listener you get who listens to every additional song, you're paying an additional royalty. It's not like a broadcaster who has a big upfront payment to build a tower, but then as much as they send out to as many audience members, each incremental audience member costs them nothing once they've built that tower. For streaming, each incremental listener costs them more in music royalties. And it gets really hard for an independent webcaster or a small webcaster to grow to be a big webcaster unless they've got lots of money behind them, because of that incremental paying before you can get to the size where you're bringing in enough revenue from advertising or subscribers to pay those digital music royalties. So that's why you see most of the new entrants in the digital music field being companies that basically don't care about money, because they've got money to burn from their other sources of revenue. You've got the Amazons, and you've got the Apple Musics that have jumped in a big way into the digital music fields, because Apple makes its money from devices, and so really does Amazon. Most of the Amazon Music money is coming from sales of Alexa. And Google now, as Google is for whatever reason lagged in the music side, but now they've got, I guess it's Google Music that because they've got Google Home to push out there, that will be playing more music. Although they're huge in the YouTube side of things, that doesn't pay these royalties because it's all user-generated content. And there's a whole different user-generated content regulatory scheme for paying music royalties, and basically they get away with paying less than any of these digital music services because of the various protections for user-generated content that are subject to current review. All those issues are ones that you really have to look at in assessing the ability of the digital media to compete in some ways with traditional media, and the possibility that at some point these kinds of royalties will be imposed on traditional media as well, to supposedly level the playing field, but in many ways to undercut traditional radio. On the broadcast side of things, I think one of the big things that we need to watch is what happens with ownership regulation. Does it still make sense to require that there be, multiple owners in every market? Years ago, there would have been 5, 6, 10 newspapers in every market, other than New York City, and I'm not sure where else. There's one newspaper, if that, in every market. And in most markets, that newspaper's got maybe a page or two of local content, and then a bunch of stuff that comes from someplace else, and it's not the newspaper that you used to have. There were reasons that happened, economic reasons, but to require that there be 3, 4, 5 radio operators in that same market, or 3, 4, 5 TV operators in some of those same markets, that doesn't, I don't think, make sense in the long term for the same reason that newspapers have changed over the last 20 years, essentially the digital competition that's undercut their revenue base. So I think that's going to be a significant argument that we're going to see going forward. And I think regulation of the tech sector will be the other place to watch how this regulation that's being kicked around in Congress eventually shakes out. Will there be regulation that cuts back on some of the size of these tech companies, just like back in the day, AT&T was broken up because it was feared that they had gotten too big, and Microsoft was subject to all sorts of antitrust litigation. Will there be breakups of some of these tech companies or other regulations that somehow try to level the playing field with other sources of media? So I think those are kind of three buckets of places that folks should be looking at for the future.
I think digital disruption is a great place to end our conversation. For the students, we've got some housekeeping to do, so please hang around. But Roger, thank you for connecting us with Mr. Oxenford. It's been a fascinating hour. Really appreciate it. Let's give him a round of applause. It's been great. Thank you. Thank you so much. It's been nice to meet you.
I've enjoyed it, and let me know if I can help anymore.
All right.
That's right.
Thank you.
And I agree with that. I'd like to say that in my career, people have been very helpful to me. And so if any, Jeremy, if any of your students want to reach out, I'm happy to talk to them.
Very good. And I'll share your newsletter as well, so they can see what the work is that you do.
Yeah. As Roger said in the chat box, I do write a blog on broadcast issues. It's called Creatively, the Broadcast Law Blog, broadcastlawblog.com. Check it out if you're